the counterclaim is filed in response to the main suit.
Yes.
And if the main suit is withdrawn,
Yes.
then it would mean that the substratum of the counterclaim will naturally collapse, and you would have to treat it as a stand-alone claim, or they would have to file a fresh claim as against with respect to the counterclaim.
I thought a counterclaim is a claim. It's a cause of action on its own.
Yes.
So can it survive the withdrawal of the? For instance, if a plaintiff withdraws files a notice of withdrawal of the plaint and or the claim, and there was a counterclaim in that suit, would the counterclaim survive that?
Yes, it would survive the claim, because a counterclaim is a claim in itself against the party who has initially filed the suit, and it is filed in a way to promote and dealing with matters expeditiously in terms of justice, access to justice in matters of civil procedure.
Okay. Now, if you are a judge and a suit is brought and you had the evidence and there is a counterclaim, and for some reason the defendant who now has filed the counterclaim does not turn up to give evidence or provide evidence in support of the counterclaim, how would you deal with that as a judge in terms of your judgment?
If the defense does not prosecute its claim, then in the judgment I would indicate that they did not prosecute the claim.
So how would your judgment first run? How would it look like?
In terms of the structure?
Yes.
They would have the parties. They would have the parties known.
Yes.
Then I would have the title
Yes.
of the judgment.
Yes.
Then I would describe the parties, including now the one who has filed the claim.
Yes.
I would then proceed to give a brief background on the pleadings that have been filed.
Yes.
I would also proceed to indicate the positions, the different positions that the party have stated, meaning
Yes.
the plaintiff's case,
Yes.
the defense or the counterclaim, what it's all about, and I would also reduce the issues that have been.
So what will be your conclusion in terms of the claim by the plaintiff and also the counterclaim? How do you deal with that?
For the claim by the plaintiff, I would indicate whether it has succeeded,
Yes.
or not.
Yes.
Then for the claim by the defendant,
The counterclaim.
the counterclaim, I would be able to, because it has not been prosecuted, then it would have failed because it has not been prosecuted by the defendant.
So will you make a comment on the counterclaim?
The comment would mainly be to disclose that the counterclaim was present in the pleading when the plaint was being filed, and that it was not prosecuted.
Okay. So actually what I wanted to ask in summary is, can the judgment be complete without a remark or without you analyzing the counterclaim?
No, the judgment has to analyze and mention, because it is the one suit that was filed, the main plaint. So you'd have to include all the pleadings that were filed.
Okay. Yeah. Then lastly, what are the principles that you consider before you grant security for costs? Security for costs.
Security for cost is a principle on the granting of stay during appeal.
No, not that one. There is a standalone security for costs.
Okay.
You know about it?
Yes, I do.
Yes.
When analyzing the security for cost, I would look at the value of the suit in question. I would also look at the nature of the suit in question and whether there is a prescribed security that needs to be deposited in view of the matter by way of legislation, if there's any provision that talks of the cost that would be deposited by law. I would also look at the question of the nature of the proceedings that are before me, and also consider the parties.
Okay. And then lastly, let me just ask, you're fairly young.
Yes.
And judging is not only a high calling, it's a high office. It means that you are actually judging the affairs of the men and women of this country. Serious affairs about their lives, their property, their rights, and many other things, because the High Court has, unlimited original jurisdiction, both criminal and... Now, what do you think would distinguish you, because you are fairly young, would distinguish you against the other candidates, so that we should consider you as a judge?
Thank you, Honorable Commissioner. As you've rightly said, becoming a judge is not only a matter of calling. And throughout my career, it has shaped me
No, I don't want you to talk about your career. You've already said it.
Yes.
This is a serious office. Okay? We've already read your CV. You made a good introduction about what you've done and your experience as a county solicitor. Mm-hmm. That is well noted. Now, this is a real high office. Okay? Mm-hmm. So you are going to be sitting and judging serious affairs about Kenyans. The other candidates who've come before you and who will come after you, who are fairly experienced. Now, as a young advocate, you are 36. What, in your pitch, what should we consider that sets you apart, that we should consider when we are weighing, one against the other, to say that Mr. Faraji is indeed worthy of this high office?
To answer your question, Honorable Commissioner, I believe the law should be applied, and the role of a judge is to apply the law is also to weigh and balance. I've been in positions where I've had to apply the law and create that balance and ensure that justice is done to everyone who I've interacted with in the course of my career. That is what I would bring if I am successful in this venture. It's not a question of age. I understand that age would be a variable of factors you've rightly stated, but it's a question of how do you apply the law, what principles, what values do you stand by, are you able to ensure that justice is done for the people of Kenya or those people who appear before you? How do you relate with the court, with the stakeholders? How do you relate with clients who appear before you? And the experience will be gained progressively. Currently, I might be young or appear young, but the skill and expertise that I've gained over a long period of time in my career have equipped me, and that is why I offered myself to join this institution of judiciary, to be able to impact positively, to transform the country in as far as our values, our principles are concerned.
All right. Thank you. So you say you are young in age but old at heart. Thank you, that's all.
Yeah. Just one clarification about security for courts. Which legislation or which rule provides for security for courts in Kenya?
What I meant when I said in applying what...
No, I mean, which legislation gives it life? Which provision of the law do you invoke when you are requesting or adjudicating on security for costs?
The civil procedure.
Which rule?
Rule.
Is it a discretionary order?
It is a discretionary order.
Now, you mentioned when you were being questioned that you'll be guided by legislation. You'll grant it if it is provided for in legislation. So give us an example of two legislations that provide for security for costs. Unless I misunderstood you.
The civil procedure, and in instances of election petitions, there's usually a security of course that is deposited in line with the Election Act.
How would you know the nature or the amount?
By actually looking through the pleadings or the veracity of the nature of the case or matter that is before me. For the election proceedings or the Election Act, it provides for a certain amount of money that should be deposited in court for various matters, or various matters.
Thank you, Honorable Chair. Good evening once again, Council.
Good evening.
Do you need some water break? Are you okay?
I am okay. We can proceed.
Okay, good to hear that.
Thank you.
From your CV, it appears you have done quite a lot. You're a patent agent. You are a member of CIAB. At your age, you are Solicitor General. Sorry. County Solicitor. My apologies for that.
That's okay.